President Biden is blasting the Supreme Court for overturning a lower court ruling in South Carolina and creating a new, much higher standard to prove that a congressional district has been racially gerrymandered. The president saying in a statement that the decision, quote, threatens South Carolinians' ability to have their voices heard at the ballot box, and the districting plan that the court upheld is part of a dangerous pattern of racial gerrymandering efforts from Republican elected officials to dilute the will of black voters. Joining us now is former federal prosecutor and Georgetown law professor Paul Butler, and Janai Nelson, president and director counsel of the NAACP Legal Defense Fund, a group among the groups that argued against this redrawn map. Paul, first to you. Justice Alito, writing for the majority, said, quote, without an alternative map, it is difficult for plaintiffs to defeat our starting presumption that the legislature, that references South Carolina Republicans, acted in good faith. What does this mean for redistricting? For them to say, for the High Court, for Justice Alito to say that they should presume that they acted in good faith after the history of racial gerrymandering and discrimination against black people in the South, in particular?
Yeah, so this is South Carolina, where Republicans control 6 out of 7 of the congressional districts. There's one district that is led by an African-American Congressman, Clyburn. Nancy Mace, the Congresswoman, won this district in 2020 by just 1%. So the Republican lawmakers in South Carolina wanted to make it a safer district for Republicans. The way they did that, according to 3 federal judges who heard evidence, was they bleached the African Americans out of that district. They moved them to Congressman Clyburn's district. So that's what the Supreme Court was considering. Again, 3 federal judges had already...
Federal South Carolinian judges.
Yes, federal judges from South Carolina had said that, again, they had heard evidence to lead them to the conclusion that the motivation was race. And what Justice Alito said in his majority opinion yesterday is it was politics, not race. And even though they're closely intertwined, if it's politics, then the Supreme Court shouldn't intervene. It's all good, is what the court said.
Because if it's not race, it doesn't violate the Constitution, allegedly. Janai Nelson, the LDF, the Legal Defense Fund, argued against this newly redrawn map before the Supreme Court. Your reaction to this ruling, a 6-day ruling, Elena Kagan wrote for the dissent, but it's just stunning considering the trajectory of voting rights in our country in the last, since 2013.
You know, it absolutely is stunning. This was a clear case of a racial gerrymander. We gave extensive evidence at trial of the fact that the court, the lawmakers relied on race. They had data in front of them as they were drawing these maps, and they were looking specifically at black voters to create a partisan advantage. And so we know that 8 years ago, the Supreme Court backed away from adjudicating any partisan gerrymandering claims, but they did say that if there's a racial gerrymander and it violates the Constitution, that is justiciable. That is a case that they will take and look at. We made the strongest case possible with over 600 exhibits, over a dozen witnesses, days and days of trial, and we received a unanimous judgment from 3 federal judges who saw the evidence and said, this is clearly a racial gerrymander. And when the Supreme Court reviewed the case, their only task was to determine whether these 3 federal judges clearly erred in their judgment. And the idea that they did based on the volume of evidence that we presented is just preposterous. This is clearly a politically motivated decision, and it's extraordinarily disheartening considering the crises that our democracy is facing.
And also, Janai, something that really was striking to me is Justice Clarence Thomas, in his concurring opinion with the majority, he also went after Brown v. Board of Education, saying, quote, such extravagant uses of judicial power are at odds with the history and tradition of the equity, power, and the framers' design. Now, Clarence Thomas took the seat of Thurgood Marshall, who argued Brown v. Board for the Legal Defense Fund, this landmark case that changed America forever. So I can't get over that. Tell me what your reaction is.
Well, we know Justice Thomas took the seat, but he did not fill it. And what he did in disseminating disinformation about a landmark decision whose commemoration we just honored this past Friday, 70 years since Brown, we see a Supreme Court justice who benefited from Brown, as did every American, castigating that case and misconstruing it and suggesting that it stands for something that it does not. Brown requires that we provide equal access to our democracy through education, and it's anchored in the idea of citizenship. Brown said that one of the most important functions of local and state government is to provide an education for purposes of citizenship. And citizenship could not be more clearly exercised than through the voting process. And what the Supreme Court has done in Alexander versus South Carolina is completely distort that process, manipulate it, and allow partisan actors to completely capture that process in a way that directly harms Black voters. It's an invitation to exploit Black voters for partisan gain.
Which could, of course, affect in a closely contested House, could affect other states and could affect who controls the House. Just one quick footnote, and I don't know if this is fair or not, but it's certainly been talked about. Elena Kagan, in her dissent against Justice Alito's majority opinion, twice used a phrase, not a commonly used phrase, of that this is an upside down way of thinking. Upside down. Could that be a reference to the flag?
In dissent, Justice Kagan used that phrase twice to describe Justice Alito's reasoning. Again, it's an uncommon phrase. Supreme Court justices take months to draft opinions, so maybe this was written a long time ago. Could she have taken it out, given the recent news about Justice Alito's upside down flag? She could have. She chose not to.
Paul Butler, Janae Nelson, I can't think of two better people to talk about this case, this decision. Thank you.
Thank you.